So we're gonna start with Trump, and what we are gonna do is, I guess, we're gonna save Alex for the exclusive Rumble side of this. Robert, we're gonna start with the conviction. I mean, when did it happen? It happened Thursday.
Well, coincidentally, Biden had scheduled a press conference to discuss the case a week before on that Thursday.
Well,
Purely coincidental, I'm sure.
Well, Robert,
surely a sign of high integrity in our court system.
He could not have known what the jury was going to do, but it does seem, and I'm being sarcastic, it does seem that the jury took 2 days to render their verdict, which is also stunning because they come down unanimous on all counts, although they had to, if they came down to one, come on all. But the news that really slipped under the radar that day was Biden regime quietly or very secretively authorizing Ukraine to use U.S. weapons to strike Russia within Russia. That was a. Yes. We'll just open a parenthesis.
Let's escalate. Let's see how close we can get to World War III, everybody.
That was one of. I mean, they've had so many red lines. I forget what they were. There were tanks that were one of the red lines. A certain type of long-range missile that was one of the red lines. And we're not going to do it. We're not going to do it. We did it. We did it. And now they're authorizing
power support and airplane and fighter jets.
So they did in fact do that. I mean, I confirmed it. I confirmed it as much as the media confirmed it very quietly, but everyone was on fire about the verdict. Robert, at the risk of asking the obvious, guilty on all 34 charges, and people take that to mean, oh my goodness, First question, explain it for everybody, because I have trouble, but it's better to hear it from you. How do you get to 34 charges from one, even if assuming it is a scheme? How do you get to 34 independent charges, felony charges, from one overarching criminal scheme? Assuming it was that, which it wasn't, but I'll just, for the sake of question.
By treating every single check and every single bookkeeping entry as a separate crime. I mean, it's the kind of scam that our system is too easily susceptible to because we over-criminalize everything. A fellow I shared the stage with some years ago wrote a book called 3 Felonies a Day. And his point was that most Americans commit 3 federal felonies a day without even knowing they do because of how many insane things they consider criminal behavior and get to label criminal. But so that's how they got to 34. They took each time a check was issued to Cohen and each time there was any bookkeeping entry in the books as a separate independent crime.
But I guess the obvious question is it legal to do that? Because it does seem like, I just made it as a joke. It's a good thing he didn't pay in like $1,000 checks. Otherwise, he'd have 130 in felony indictments. Is there not a double jeopardy as relates to the charges themselves when they are part and parcel of the alleged overarching scheme?
You could argue that, but the courts have ignored it. The courts allow you to piece and parcel these cases. The courts have just basically been deferential. They've been stooges for the state. They've been deferential to the prosecutorial branch. And to such a degree, they've made up law and they've eviscerated and butchered our constitutional protection and limitation on the state. And they get neoliberals cheer it because they're liberal authoritarians, but a bunch of conservatives have cheered it over the last 50 years. You got to protect, keep America safe and be secure. And that means we got to butcher the Constitution, Barnes. That's what they've been sadly cheering for so long. And now they get to reap the whirlwind and see the consequence of what that looks like when you give the state this kind of Soviet-style power over an individual.
Now, I put out a video, a vlog earlier, the sort of the pre-stream reminder. I'll give everyone the link. We don't have to go over it entirely, but I refreshed my memory after Matt Taibbi's tweet about the Steele dossier. They charged and convicted Trump of literally and exactly, except they actually committed the act and the intent of what Hillary Clinton did, where they financed the Steele dossier, which was actual election interference because it wasn't even bona fide opposition research, wrote it down as legal payments to conceal the fact that they subsidized it, reacted to it as though they didn't pay their employee to prepare it, leaked it to the FBI that leaked it to Yahoo News so that they could publish it, so that the FBI could report on the publication to go get a warrant to spy on Carter Page. And they gave her a mere FEC $8,000 violation for Hillary, $115 for the DNC, and everyone went their separate way. I'm not they literally did commit the crime that they accused Trump of having committed.
Oh yeah, it's all examples of confession through projection. And then they've done that with Trump all the way through. Both impeachments were impeachable acts committed by Joe Biden or Hillary Clinton or Barack Obama. And the same, fixing an election in the second impeachment was done by them at different points, or attempted to be done by them. And the first one, the Ukraine bribery using family and friends, was done by the Biden administration, done by Biden when he was VP and senator, but especially when he was VP, not by Trump. And they accused Trump of it. And then here, Hillary was basically illegally funding a foreign agent operation to derail the 2016 election by illicitly getting a FBI criminal investigation based on false claims against her challenger. And she actually paid out those amounts at a reportable time period before the election, unlike Trump. And she disguised it all as legal fees so that nobody knew she was behind it.
And it was paid from campaign funds, which Trump's...
Oh, yeah, exactly. It came from actual campaign funds, was for the purposes of influencing the election in ways she didn't want the world to know about, and was disguised as legal fees when it wasn't legal fees. In other words, the money, it didn't go to a lawyer. The money went to a lawyer, but not for the lawyer. And so what they did is they took Hillary Clinton's crime, which, by the way, she committed in New York, and applied it, pretended Trump did it. And what's amazing is I get, now I have all the Trump hating trolls barraging me, of course, in the Twitter feed and elsewhere. And they're like, "Oh, Barnes, you're just making this up, Barnes. He wasn't even charged for anything other than influencing the election, so presidential immunity couldn't even apply." And it's like, you guys don't even know what he was actually charged with, do you? You don't understand that the core crime is alleged that the jury found guilty was for decisions made by a bookkeeper to call a legal invoice paid to a lawyer legal services, because that was the option in the drop-down menu. For example, they presented no accounting expert witness at all, the government, that said that there was a different accounting gap requirement to describe those payments. None. Wait, there is no drop-down menu in QuickBooks that says hush money, that says NDA money, that says Ho tried to extort me option. There's no such option listed there. So, that by itself was preposterous. It literally couldn't be a crime, even if Trump had wanted to commit the crime. The booking legal services as legal services when it comes from a legal invoice and it's the only option on the menu. And of course, the undisputed, uncontroverted testimony was that bookkeeper made that decision all on her own, that she got no advice, no feedback, no direction from Trump on it ever, and that it was made solely and wholly by her. Nobody changed it after she made it, nor did anyone review it after she made it. So the very first aspect of the crime, there was a requirement to issue a directed verdict based on the facts presented at trial. Then the second issue of the directed verdict was that this entry was made for the purpose of committing another crime. But this was made for the purpose of defrauding the American people and the people of New York. And that the fraud crime alleged was that it was all done to steal an election, to impact and influence an election. The problem is, it couldn't have been. It couldn't have been this is why a directed verdict by law had to be issued. That because no rational jury, no jury at all, could conclude that Trump had committed the crime based on the evidence presented at the trial. Because first, the bookkeeping entry had nothing to do with and was entirely consistent with GAAP principles. The government didn't challenge or contest that at all. Secondly, he couldn't have been trying to have made that bookkeeping entry for the purpose of influencing an election, because the bookkeeping entry was made after the election was over.
Well, let me steelman it, Robert, and you'll tell me if it's not a fair steelman. They'll say, well, they disguised it as that even though he had already been elected and it could no longer influence the election, it could have influenced his ability to remain as president. So they could have impeached him.
Now, what's the problem with that?
Shit, I don't know. I haven't thought that far ahead. I thought it was a smart question.
It goes exactly to what I started the conversation off with. With all these fake lawyers on the internet, on Law Twitter, which is about as dumb and incompetent and corrupt as LawTube, saying that that there was no applicability of presidential immunity to the charges. But you just highlighted exactly how the case goes directly to the issue of presidential immunity. Because if it's something he could be impeached for, then it's something he's immune for, under the logic that has been made before the Supreme Court of the United States. That's the point, is that his purpose had to have been to stay president, to be president, to avoid impeachment. And that would mean that it's something that he did as president, which means it's something subject to an immunity challenge. And they don't want it to be the case. They want the crime to have been committed before he was president. So there's no immunity argument, no Article 2 argument, no impeachment clause argument. But they can't because of the timing and when the transaction occurred. The other problem is, the theory is he made a false bookkeeping entry to hide the fact that he previously made a false election report. And he made the false election report in order to influence the 2016 election. The last part is important. That's the ultimate crime that was charged. Some people are getting caught up on the second one. They think, it's all they had to prove was false bookkeeping report to disguise a false election report. But that is not what the allegation is, because they knew they had a problem with trying to bootstrap a federal crime into the issue. This will get into the Vivek's argument about a pardon in a minute. But they actually skipped that at the state level. They knew that there were serious problems with trying to do that. Instead, there was a separate state crime in New York for trying to illegally, by unlawful means, influencing an election. That's the statute that they chose as the second statute that they said he was covering up a crime for. Now, there's issues with what unlawful means they listed, because that gets absolutely insane. You listen to some of the theories on that, and it's just utterly ludicrous. But that's the actual crime was that the problem is the election report concerning the Stormy Daniels payment wasn't due until after the election. So even if they could show proof that there was a false bookkeeping entry, even if they could show Trump was the one who ordered it, even if they could prove that Trump ordered it for the purpose of covering up how he unlawfully influenced the 2016 election by covering up that he had made a hush money payment, the problem is the hush money payment didn't have to be publicly disclosed until after the election anyway. So they by law they could. This was a classic directed verdict case. There was no rational jury could conclude that Trump was guilty based on the evidence the government itself chose to present or failed to present at trial. Now, the other issue is an NDA doesn't have to be disclosed on an election report as anything other than how he chose to disclose it, as the FEC itself concluded. And as the FEC expert that the judge prohibited the jury from hearing from would have testified. And this was the former commissioner of the Federal Election Commission, to explain that this accounting entry, to give expert testimony about accounting, not expert testimony about the law. This is what the judge lied. It was about how do you book this item for a campaign finance report purposes. That's a campaign finance professional who's giving campaign finance expert testimony. And the judge himself admitted this was a matter of fact, because when he came to jury instructions, he falsely told the jury it was factually against Trump. So so all the excuses they have, he was trying to usurp the judge's role in the law. It's just nonsense by the judge's own implicit admission. So at the outset, there is no crime that Trump committed. The unlawful means to influence the election really gets nuts, because the unlawful means is either an false FEC report, which by definition could not have influenced the election under the timing issues, which the jury was denied knowing about, or it was tax evasion. So hold on a second. How could a tax report I don't file until a year and a half after the election possibly impact the election when there was zero testimony at trial that there was anything wrong on his tax returns? Because as Trump told people later, they didn't try that strategy because he didn't even take it as a deduction in the first place. So, I mean, he literally instructed the jury on a crime Trump could not have committed.
Well, and he also instructed the jury, Robert, that if you opt for the second of the three options of the predicate act, the tax fraud, it doesn't even have to result in, this is what he said to the jury, it doesn't need to result in him having paid less in taxes, which I did not. I was like, Russell Lee must have made a typo there, but he didn't. He said to the jury, as far as the tax fraud goes, he doesn't even have to have paid less than what he owed in taxes for that to be part of the crime. I didn't understand that.
It's because it's not understandable. He deliberate, and not only that, then he tells the jury that the unlawful means is actually violating another crime. It's actually an element of the offense in this instance. But he tells them that they don't have to agree on what crime Trump committed. They don't have to agree unanimously on what crime Trump committed. They don't have to agree beyond a reasonable doubt that Trump even committed it. This is, of course, a complete due process violation and makes the jury instructions invalid under New York law. And we'll get into all the different constitutional issues Trump has on appeal and why it's critical he raised those issues on appeal in that manner, because he needs to get past the appellate division of the Manhattan court and the New York Court of Appeals in Albany, so that he has robust arguments for the Supreme Court of the United States. But just for those folks out there that are confused on the crime, they're confused on the crime because the judge instructed the jury that the unlawful means, which was the core issue in the entire case, in order to commit election fraud, did not have to be decided by the jury unanimously, did not have to be decided by the jury as to even which crime it was, and did not have to be decided by the jury beyond a reasonable doubt. And they were crimes that, as a matter of fact and law, Trump could not have committed.
It is amazing, because now that you explain it like this, and now I understand where he says it's either election interference, as that was one of the three potential charges. I forget what the third one was, or it's tax fraud, which occurs after the election, so it doesn't need to be election interference. And it could
the election report, the same thing, was after the election, so it couldn't have been election interference.
Unreal. Okay.
So it was utterly absurd. It is. I was on with the one and only Tom Woods, the libertarian, fun guy. He and Michael Malice do some fun shows like how do you make a law, and it's kind of a little bit satirical about how the law is really made. But it plays off that stuff you learn in third grade with the public service. And now I don't know if you saw those in Canada.
Oh yeah, for sure. Like how the bill is made, and they got the cartoon,
the little bill,
the corny music,
steps, and you get the little cartoon and all the rest. And then they've done some like realistic versions of how the bill is made. Which is funny. You put Malice and Woods together, and they have fun. But I was talking to him I did a special podcast for him on Friday, right before I left for Orlando for the Rebel Capitalist live show, which was a lot of fun. Got to meet up and chat with some really cool folks, including Viva and little Ethan. Was that basically I said, if you took kind of a combination of Soviet show trials and Kafka's book The Trial, and you put them together for a live Broadway script, you would have the Trump trial in New York. Because it's like, okay, what would happen? What if you gave a jury instruction that said, jury, we've now shown you the man. You now must find the crime. Well, that's literally what happened. He said, there's Trump. Just take a pick and guess which one it was that he maybe committed. And if you combine the Kafka's trial of just absurdity upon absurdity upon absurdity, guilty until proven innocent, all the rest of it, that too was on full display. The problem is they made the same mistake all the fascists made and all the commies made, which is they believe that the American people believe in jury verdicts solely because they are a jury verdict. What they don't understand is Americans have confidence in an outcome when they have confidence in the process that produced that outcome. That the reason why they're called show trials is because in the American public consciousness, they're not real trials. And here, you can tell the liberal left, the lawyer left, is shocked that Americans are responding the way they are. Like them, they already had the editorials ready to go, including at the neocon, Never Trump publications like Washington Examiner, had them ready to go at the New York Times, had them ready to go with their, pontificating on MSNBC and CNN and all the rest, saying, this election has changed. We have to, he's now a convicted felon. The jury has spoken. This guy even tried to do this with Robert Kennedy. It's something that was live because the verdict came down right before Kennedy went on. But Mr. Kennedy, you recognize a jury made this determination, right? The Times of London tried the same with Alan Dershowitz. You realize if the jury made this determination, it must be true, right? Like the nitwits at LawTube. Oh, a cop alleged it. It must be true, right? That routine. And as Dershowitz said, as Kennedy said, as anybody with an IQ over 50 said, no. If you had 12 Klansmen convict Martin Luther King in 1963, you wouldn't go, oh, the mighty jury has spoken. We must now defer. No. A trial is only as good as the trial is good. The outcome of a trial is only something we can have confidence in to the degree the process by which that trial was conducted we can have confidence in. Here we have a conflicted prosecutor in violation of Trump's rights, a conflicted judge in violation of Trump's rights, a conflicted jury because they were partisan, they were prejudicial, they admitted so in their own jury answers. They came in wanting to convict the defendant. It was kind of like, by the way, the O.J. Simpson civil jury. Everybody, Barnes, the civil jury did find him guilty later on. They were put on the jury based on whether or not they already had concluded he was guilty before the trial even started because of how the judge handled that case. You are constitutionally entitled under the Due Process Clause of the United States Constitution to overrule and overturn any Kafkaesque trial, any show trial. And this Broadway show is not selling with the American people because it shouldn't sell with the American people for the same reason no show trial ever sold with any domestic population, because they can't have confidence in the outcome because they can't have confidence in the process. And we'll get to all of the ways in which, and for those people that wonder, okay, what protects me from a Kafkaesque trial in America? It's the Due Process Clause of the United States Constitution.
I was going to say nothing, Robert, but so they're going to, the next step in this process is what month is he coming back for sentencing? July?
Yeah.
And that's
July 11th, a few days before the Republican National Convention, and a week after July 4th. I thought they were going to be dumb enough to actually put it on like July 5th or something, like right around July 4th.
No, they picked the perfect time, a week before the convention in I think it's Milwaukee. In Milwaukee. Robert, now the judge in theory,
we might have to go up to Brewtown.
Well, I believe I got my credentials for that event, and it's just a question of whether or not I can make it down.
I lived in Milwaukee for several years. Got a bunch of buddies up there. There's a real cool cigar bar there, Shakers in the South Side. I might have to make the rounds of the old Brewtown.
Robert, your what's the word? Your appreciation of fear and danger is far different than mine. I was talking to the cab driver about Milwaukee, and even the cab driver said it's gotten bad.
I even got friends on that side of the aisle in Milwaukee too, so I'll probably be okay.
Okay, so the judge is gonna sentence the week before the RNC convention, give or take. In theory, I mean, some people are saying he's going to lock him up, put him under house arrest, whatever. In theory, I mean, we're not in the realm of theory anymore. We're past Rubicon after Rubicon. Any sentence would be suspended pending appeal, given the nature of the likelihood of the type of penalty versus the time it would take for the appeal. What do you think is going to happen? Are they going to order him on house arrest or order him locked up for a day and not suspend, notwithstanding appeal?
We'll see. The judge's options, the maximum sentence he can issue is 4 years.
Per felony.
I think the way it works is 4 years combined. That often what they do in the sentencing provisions is they cap them. The one way they limit the due process implications of multiple prosecutions for the same basic offense is they usually cap the sentencing. So what I had seen was that 4 years was the effective cap, but you never know for sure. I mean, maybe he could. I suspect under New York law, he's not legally entitled to aggregate the offenses.
I thought I do. I just wanted to make sure because I said 180 years, and I just wanted to make sure. I say it as a joke.
180 years.
Yeah,
but I think under New York law, he's not allowed to.
Not 100. Oh, these mother effers, Robert. It wasn't Trump that said he faces 180 years. It was the media that said it.
Yes.
The claim. I'll go back and find it was the media that said it, not Trump. Okay, I'm sorry because I know that they said it.
As a practical matter, that you can pretty much rule that out. I would say as a practical matter, the realistic range is probation to 4 years in prison. Now, in most sentencing states these days, they follow some version of the federal guidelines. And what I mean by that is they have their own state guidelines. And these state guidelines are meant to standardize sentencing risk so that you don't get AWOL sentences. You don't get, real generous treatment for some, real punitive treatment for others. So someone in Trump's category, this kind of offense, which fundamentally is a misdemeanor, even though they've now elevated it to a felony, for someone who has no criminal record at all, not part of a gang or any ongoing criminal operation at all, is over 70, that a 95% chance that he would get probation. The X factor is with this judge. Will this judge continue his pattern of prejudice and institute an insane sentence? That's possible. Now, and will he revoke bail? Now, I told people, I discussed it with Mark Robert and others, that I believed that even if there was a guilty verdict, Trump would not be immediately remanded and he would continue to be released. That prediction turned out true. In fact, when the judge inquired about it, the government made clear he's not even out on bail and they're not requesting any. So the prosecution doesn't want a prison sentence that's immediately served at all. And because this whole case is about influencing the court of public opinion, and the crazier the case gets, the worse the reaction will be to them in the court of public opinion, not the worse for Trump. And so I still think that's the operating motive here. And as long as that is, you're extraordinarily unlikely that Trump faces any prison sentence. Any prison sentence will be, the Republic reaction will be even massively more against what they're doing to Trump and even more in Trump's favor. That the more they martyr Trump, the more the public rallies to Trump. And we'll see if they can start to figure that out or not. Now, the other thing he can do is, let's say he issues a sentence. Then the next question is staying or suspending the sentence pending appeal. You can also issue what's called a suspended sentence that's effectively probation. You can say, I sentence you to 4 years in prison, but I suspend the sentence while you serve probation. As long as you serve probation, you'll never have to serve the sentence. So people should know that's the difference between a suspended sentence and suspending the sentence pending appeal. Separate matters legally. But he could also be granted bail pending appeal. And if let's say the judge orders immediate remand, that doesn't normally happen. Normally they give you a right to self-report. And when the sentence is small in a case like this, you get bail pending appeal, or you stay or suspend the sentence pending appeal. If the judge denies it, then Trump can immediately take it to the appellate division of that court. If they deny it, he can then immediately appeal that to the New York Court of Appeals. And if they deny that, New York Court of Appeals is their equivalent of a New York Supreme Court. And if he wins that, then he can take it, because of the very unique federal constitutional issues we're about to get into, he can then take it to the Supreme Court of the United States. So my prediction is Trump doesn't serve any time in jail. Trump doesn't serve any sentence pending the election or pending the appeal. And for the reasons I'll articulate, even if the appellate division of Manhattan corruptly refuses to overturn this verdict, which will be embarrassing and humiliating for that appellate division, and will make them a mockery to the entire world. And then if the New York Court of Appeals does the same thing, a New York Court of Appeals that was willing to overturn Harvey Weinstein's verdict, if they refuse to overturn this joke of a verdict, then I believe that the Supreme Court of the United States will take up the case and will overturn the case for all the reasons I'm about to articulate. Of course, they may issue a decision in the next 30 days that requires this case be thrown out.